Alyson, if you'd like to share your screen, we can go ahead and get that set up. And then everyone, as we're going here along, as Alyson is giving the workshop, if you have any questions, please don't hesitate to put them in the chat. You can also, if you'd like to ask a question outright, I think we'll save the questions to the end. Does that sound about right, Alyson, if we save them to the end, the questions? Or
yeah, I think at the end will be a little bit easier.
Perfect. Okay, so we can definitely do that. And while Alyson is talking, if you wouldn't mind, all of us will keep our cameras and our microphones turned off just to limit the extra noise and the keep that bandwidth down to a minimum if we can. So quick introduction about Alyson. We're so grateful for her being here with us today, for speaking to all of us here at the REC, and for really supporting us at the REC Innovation Lab at Miramar College. So Alyson has been working with us for a little over a semester. You started last semester, right? Was it last semester?
At the very end of last semester.
Very end of last semester. So we just, this is our first real semester then together. And Alyson is really an entrepreneur herself, in addition to being an attorney. She's also an educator, and she's going to be talking to us today about California employment law. And I'm sure that there is so much that we could cover here. And so I'm sure this is going to be a very, very high level, but hopefully this will get you enough information so that you can maybe know what you don't know, or know where you need to look a little further or learn a little more, right? So with that, I will pass it over to Alyson and let her talk a little bit more about herself in the presentation. So take it away, Alyson.
Hey, thank you for the warm introduction, and hello to everyone. So after working for several years in private practice and then in-house for a company that did HR and staffing, I now have my own firm, and I provide fractional general counsel and other legal services to startups and growing businesses. Also, as you heard, I am an educator. I teach at the Santa Barbara and Ventura Colleges of Law, and I also do mediations for litigated cases.
So Alyson, I didn't mean to interrupt, but I was just wondering, could you just tell us just fractional, what you mean by that?
So fractional general counsel, it's very similar to, you might have heard of like a fractional CFO or a fractional CMO. And basically what it means is you have somebody who works in-house, like a normal legal team or like a normal in-house counsel, but only on sort of a part-time basis. So ranging anywhere from maybe a quarter of their time to up to a half of their time or a third of their time, depending on the needs of the company. So you get the benefits of an experienced legal counsel, but you're not paying for a full-time 100% in-house employee.
Wonderful. So kind of the gig work of attorneys.
Yes, but you get that long-term relationship.
Oh, with that long-term relationship, yeah. Awesome. Wonderful. Wonderful. Okay. So I will, I'm going to turn off my video and microphone, and I'll leave it to you. If you need anything, let us know. And yeah, take it away. Yeah.
All right. So one of the main areas that seems to trip up most business owners, especially in California, is employment law. So today I'm going to give you a little crash course in employment law to help you avoid some of the big pitfalls that employers tend to fall into. So first of all, let's get started with a little overview of some of the laws that can apply to your business. Okay. So this is just a quick overview of the main employment laws. And these include protections against harassment, discrimination, disparate treatment, and other adverse employment actions such as termination or retaliation. And you'll see that the main ones are the Age Discrimination and Employment Act, also known as the ADA, the Title VII of the Civil Rights Act, and the American with Disabilities Act, also known as the ADA. And that's at the federal level. At the state level, you have the Fair Employment and Housing Act, also known as FEHA. So protected categories include race, sex, religion, age, disability, and certain medical conditions. And the ADEA and FEHA, they cover employees aged 40 or older, which is always sort of surprising to people because we think age discrimination, we think people, you know, much older than 40. It's actually just 40, a lot younger than we think. And as you'll also see, the ADEA only applies to employers with 20 or more employees. And then all of the federal laws, they sort of drop off if you have less than 15 employees, but FEHA applies to anyone with 5 or more employees in California. And no matter your size, even if you just have one person, a temporary assistant, an intern, anything like that, you are still covered by the anti-harassment laws in California. So just something to always remember, it doesn't matter your size, you can still have someone bring a harassment complaint against you. So the additional state legal bases that you can also run into are wrongful termination, violation of public policy. And this is a common law tort, so you don't need to file a DFVH or EEOC complaint or charge to bring this claim. And I'll talk about that a little bit later on, since that can be a little bit confusing. And then there's also California Civil Code section 52.1, which is the Bain Act. And this arises when there are threats of intimidation or coercion. So it's very limited. And it also has to involve interfering or attempting to interfere with the exercise of enjoyment of an individual's rights secured by law, which is a fancy way of basically meaning you break any sort of labor law or constitutional right or a law protecting against physical injury. And this includes a little broader definition of protected characteristics. So sex, race, disability, religion, and then things like political affiliation and primary language as well. And then California Civil Code section 51.7, also known as the Ralph Act. And this is a little bit different because it really requires making or threatening or sort of a violent incident or an intimidation, a threat of violence, once again, based on those defined characteristics. So looking again, sex, race, disability, etc. It also includes making or threatening to falsely report someone to law enforcement. So that can sometimes come up in sort of an immigration setting. Other laws that might apply that aren't on the slide are just general whistleblower statutes. California Civil Code section 51.9, which deals with sexual harassment in certain kinds of professional relationships. So taking advantage of your clients or something like that. And California Civil Code section 51, which protects against discrimination by business establishments. So I know we've talked about some of these big laws regarding discrimination, harassment, and retaliation. And I want to talk a little bit about something a little bit different and switch gears and talk about mandatory trainings in California. So California requires that you provide sexual harassment and abusive conduct prevention training for all employers that have 5 or more employees. It's a new law and it really reduced, it used to be you had to be a really big employer and now it's just 5 or more. And something to keep in mind is this 5 or more includes temporary employees, so part-time employees or just seasonal employees as well. So you have to kind of look at the time when you have the most people working for you to calculate the number. And included within the definition of sexual harassment is all gender-based discrimination and harassment. So that includes gender identity issues or sexual orientation as well. It also includes retaliation that is focused on gender-based issues. And if you, for your supervisory employees, like your management employees or your sort of like your owners or founders, if you have more employees, you have to do 2 hours every 2 years of training. And for non-supervisory employees, so pretty much everyone else, it's 1 hour every 2 years. And there are free trainings that are provided by the state to help you comply with these requirements. So you don't have to hire someone to do it or try to create your own. So definitely something to take advantage of. Whenever the state gives you something free that they tell you is going to satisfy the requirement, you should do it and use it. And then on top of the required trainings, I do recommend that you do non-mandated trainings. So these would include things that are non-gender focused discrimination or implicit bias training. So dealing with issues such as race or age discrimination or harassment. I think it's always best that you try to be more well-rounded and do more than the minimum. Also incident-specific training. So this happens when somebody has raised a complaint, maybe they are complaining about racial discrimination at work. You could do a training that focuses on that so that everyone sort of knows how to behave properly or what things could be problematic. Training also is a really effective legal mitigation technique. So I definitely do recommend you do it more than required. Ideally, at least once a year. Really shows that you're trying to make sure that your work environment is a safe one. Also, you want to keep detailed records of who attends trainings and follow up with any individuals who have not attended trainings, specifically the mandatory trainings. You want to make sure everyone who needs to do those trainings has done them. So hopefully this seems kind of straightforward, but we're going to move into the California's wage and hour laws, which are a little bit more confusing. So let's start off with the basics. So when is an employee an independent contractor and when are they a W-2? So a lot of people want to use independent contractors, but just because you call someone an independent contractor or pay them via 1099 does not mean that they are actually an independent contractor. And employers can be held liable for misclassifying an employee as a 1099 versus a W-2. So in 2018, there was this case called Dynamics, and it basically came down and changed everything about how we in California think about independent contractors versus W-2s. And since then, the laws have been changing almost yearly to sort of deal with the fallout from that case. So the most current laws went into place on September 4th, 2020, and you can find them at Labor Code sections 2,775 through 2,787, if you really want to go in depth into them. So there are a lot of exceptions for different types of professionals who you can do 1099s for and don't have to be W-2s. Some of the big ones that come up frequently are graphic designers, physicians, lawyers, architects, and also commercial fishermen. Probably not as big an issue for you, but we do have a lot of fishermen in California. So, but if you're not following into one of those exemptions, then you have to pass this thing called the ABC test. And as you can see, it's sort of a misnomer because the letters have nothing at all to do with the test, but that's what we call it. And so that's sort of like the term that we have to use for it. So unless an exception applies, all three of these factors must be met or the person will not be considered an independent contractor. So the first one is lack of control. And the legal terminology is the person is free from the control and direction of the hiring entity in connection with the performance of the work, both under the contract for the performance of the work and in fact. So putting aside that sort of legalese language, basically, if you treat that person like a regular employee, so you supervise their work, you're managing the project they're working on like on a day-to-day basis, you haven't met that factor. You're controlling them. So in those cases, they're a W-2 employee and not an independent contractor. So if they're sort of working independently, independent contractor, possibly. If not, W-2 employee. The next one is outside the usual course of business. So this means the person performs work that is outside the usual course of the hiring entity's business. So they're doing something unique or somewhat sort of one-off for the company. They can't be doing the same exact work as other employees within the company or providing the core services or work that the company is known for. And the last one, C, it's basically summed up by an independent provider. So the person is customarily engaged in an independently established trade, occupation, or business of the same nature as that established in the work performed. Once again, it's a very fancy way of saying, do they have their own business where they provide the same services they are providing to you to other companies? Basically, are you just sort of hiring them as a company versus as an individual? So if all of those are met, lack of control, it's outside the usual course of the business, they're an independent provider, then yes, you can 1099 them. or if they fall within one of the exceptions. Otherwise, they have to be a W-2 employee. So the next big wage and hour issue for employers is salary versus hourly, or exempt versus non-exempt. And sorry, my computer froze there for a second. Okay, so what's the difference between salary and hourly, you might ask? Well, salary employees get paid a fixed amount no matter how many hours they work. And hourly employees are paid based solely on how many hours they work. And the big legal difference is that salary or exempt employees don't get overtime and they don't have the same meal break rules. So almost all employees are going to be hourly or non-exempt employees just because of the nature of the work that they're doing. And to be properly classified as a salaried employee, the employee must pass the base salary test and fall into a specific exemption. So the base salary test basically has to be that they earn monthly twice or more what an hourly employee making minimum wage and working 40 hours a week would make in a month. So they have to earn twice as much as sort of the minimum wage, basically. And the salary floor doesn't change if the salaried employee only works part-time. So you don't just cut that number in half or something like that. It has to be double what like a minimum wage person would earn in a month, no matter what, even if that person is only working part-time. And then the exemptions that apply, the two big ones are executive and professional. There's a couple other ones and some of them are industry specific, but these are the ones that are most likely to come up. So that's why I'm kind of focusing on them. For the executive exemption to apply, employees must have duties and responsibilities that involve the management of the company or a recognized subdivision or department within the company. They must supervise other employees. They must have the ability to hire and fire other employees or have some significant say in the process of promotion or disciplining. So they have to sort of be involved in those high-level hiring decisions. They must, as part of their job, regularly exercise discretion and independent judgment. So once again, they have to be able to sort of work on their own independently in certain ways. And the employee must be primarily engaged in this exempt work. So more than half of their time is spent doing exempt or higher level work. So one of the things that this comes up a lot is, for example, assistant managers who often do the same work as other employees, but have some minor sort of supervisory duties. They're typically not considered exempt because they're not spending 50% or more of their time doing those higher level activities. For the professional exemption to apply, you have to be a licensed or certified professional in certain identified professions. And those include, but are not limited to, law, medicine, teaching, or accounting. Those are kind of the big ones. Or you have to be engaged in an occupation that is commonly recognized as a learned or artistic profession. So, you know, and that comes more like an artist or performer, musician, something along those lines. But because it's California and we do have such a tech community and they have amazing lobbyists, we have an additional rule for our computer software professionals. So on top of what you just heard, computer software professionals, to be considered salary and non-hourly employees, have to make over $98,000 a year. So it's a really high bar. That's much more than double minimum wage. So that's really something to keep in mind, because a lot of people think like, oh, well, I'm paying them a good amount of money. It's probably not going to be high enough. So this annual base salary of $98,000, it goes up each year on January 1st. So this is only for 2021. It will go up in 2022. So if, for example, your head software developer is not making this much a year, even if they are, you know, a vice president and make more than double the minimum wage and would normally be considered to fall under the executive exception, they aren't exempt, and you need to pay them as hourly employees. And This includes like software designers, developers, testers, and oftentimes also IT team and your support desk if you have that. And on top of that base salary requirement, they also have to be highly skilled, primarily engaged in work that is intellectual or creative, and doing work that requires the exercise of discretion and independent judgment. So you may be asking yourself, why does this matter so much, whether someone is hourly or not, or exempt or non-exempt? And it goes back to the rules, the wage and hour rules. So the main area this comes up is in meal and rest breaks. So first of all, you should make sure that all your hourly non-exempt employees are recording all of their time, including the start and end times of all their meal and rest breaks. If you don't have good records of them taking timely meal and rest breaks, then there's an inference that you weren't providing code compliant breaks. And if there's ever a dispute over wage and hour issues, you're kind of out of luck because you don't have any documents to show that you were in compliance. So it's really important to make sure you document all the meal and rest breaks that your employees take. So hourly employees that work more than 5 hours in a day must receive an uninterrupted 30-minute meal break. The meal period has to be taken before the start of the 6th hour of work. I know it's kind of confusing. There's all these different numbers in here, but that's how it works. So they work more than 5 hours, they have to take a break, and they have to do it before their 6th hour of work starts. Also, meal periods are not paid. So something to keep in mind too, another really good reason to keep track of everyone's time entry is because you don't want to be paying for their meal time if you don't have to. Meal periods can be waived if the employee works less than 6 hours in a day, but it has to be a mutual waiver. Like they have to agree to it. You can't just sort of be like, hey, you're going to waive this. They have to agree to it. And ideally, you want to, once again, get that in writing and document it each time if possible. If an employee works 10 hours or more, they need a second 30-minute meal period, which must be taken before the start of the 11th hour of work. I know, a lot of math. And the second meal period can only be waived if the employee works less than 12 hours in a day and the first meal period was not waived. People can take their meal periods kind of earlier in the shift, so they don't have to work 5 hours and then take their meal period. So you can keep that in mind when you're scheduling things like that. And once again, there's certain specialized industries like motion picture and healthcare that have slightly different rules. So if you're operating in that space, you want to kind of make sure you look those up. Then we have rest breaks. So for every 4 hours of work, you have to have a 10-minute rest period. And an employee that works less than 3.5 hours in a day is not entitled to a rest period. So just those very sort of short shifts where you don't need to give someone a rest period. Rest periods are paid, so there's sort of a tendency not to record them on the time entry because they're short and they're paid anyway. Once again, I always recommend that you record everything just so that you have records that you are in compliance with the law. Rest breaks should be taken roughly in the middle of each 4-hour period. So the rule of thumb is 1 rest period for shifts from 3.5 to 6 hours, 2 rest periods for shifts from 6 to 10 hours, and 3 rest periods for shifts from 10 to 14 hours. And rest periods are on top of and separate from meal periods. So you can't kind of like, well, you got a meal period, that's your rest period. Nope, totally separate, have to keep them separate. And one of the reasons why this is very important to keep track of and make sure that you do give people their rest and meal periods in a timely manner is that for any unwaived late interrupted, like let's say they start taking their rest period and then you call them back to do some work, so that counts as interrupted, or a missed meal or rest period, an employee is entitled to an hour of their wages. So they miss their 10-minute break, they get an hour of pay. Their lunch is late, they get an hour of pay. So something really, really that you want to keep track of. And if you do have to make these sort of premium pays, that's what we call that extra hour, you also want to make sure you're documenting that and clearly showing that that's what you're paying. Like you're not just paying them for an extra hour of work, you're paying them for the missed lunch break or the late lunch break or the interrupted rest period. So There's a couple other wage and hour rules that also cause problems for everyone. So I just want to quickly go over those as well. First of all the time someone works who's an hourly employee, including any COVID health screenings, security checks, off the clock work errands like before work or after work, that all has to be compensated. And that all goes into factoring whether or not they get overtime. So overtime is earned whenever an hourly employee works more than 8 hours in one workday, works more than 40 hours in one work week, or works a 7th consecutive workday in one work week. And overtime is calculated at 1.5 times an employee's regular hourly wage. There's also this thing called double overtime. So whenever an hourly employee works more than 12 hours in one workday or works more than 8 hours on a 7th consecutive workday in a work week, then they get double overtime. And it's just what it sounds like, twice an employee's regular hourly wage. Another thing to keep in mind is you have to provide accurate itemized wage statements. This is usually part of the pay stub that accompanies like an actual paycheck or the digital, like non-cashable copy of a direct deposit paycheck. But even if you are paying in cash, you have to provide this. And you have to provide this to all employees, whether hourly or salary. Itemized wage statements have to be completely accurate, and they have to include a ton of information, which is oftentimes why people go and have somebody help them with them. And there's a lot of companies that will do your payroll and your wage statements. But you have to include the gross wages earned, total hours worked, including any overtime hours, all deductions made from the paycheck, including taxes, the net wages earned, the beginning and end dates of the period of time for which the employee is being paid for, the name of the employee and the last 4 digits of their social security number or employee identification number, the employer's legal name and business address as recorded with the Secretary of State. There's been a lot of cases where somebody's using like a PO box or a mailing address that's not their official address as an employer, and that actually can cause problems, and you can get sued for that, even though it seems like not a big deal. It unfortunately is. And also you have to show all the different hourly rates that they're getting paid. So like regular, overtime, holiday, whatever it is, and how much of the number of hours they worked fall into that. Also, I would recommend you include any vacation or sick time, and any used vacation or sick time, and any premium pay. That's not required in the itemized wage statements, but that's information that helps you to show that you've been properly complying, and employees are always supposed to be able to see their vacation and sick time that's available to them. So this sort of helps with that. And you may be sitting there going like, well, this is silly. It's just ridiculous paperwork. But penalties accrue per pay cycle, and any wage statement violations, they start at $50 a statement, go up to $100 statement. It is capped at $4,000, but that still just melts up really, really quickly. And it's something that you can correct easily. Last thing, all wages earned, including premium pay and unused vacation time, must be paid out at the time of termination. So if you are ending your employment relationship with someone, you need to pay them that day. And if an employee quits without providing advance notice, you have to pay them within 72 hours of their last day of work. If you fail to do this, waiting time penalties can apply, and those are earned, they're calculated based on an average daily rate of pay for that employee, and they're calculated daily for up to 30 days, including weekends. So that also can really mount up fast, even if you're just like a day or two late. So make sure that you have all of that sorted when you have to change the status of the employee relationship. Let's see. Another thing to remember, and this is something that people usually forget just because, once again, you have so much going on when you're running your own business. You have to have workers' compensation insurance. So if a business employs 1 or more employees, they must provide workers' compensation benefits. And you can't pass on the cost of that workers' compensation insurance to the employee. So it's not like health insurance where you can kind of pass it on to them or have them pay for part of the group plan. You have to shoulder the whole cost of workers' compensation insurance. So this doesn't apply to sole proprietors who have no employees. So don't worry if you're solo. You can kind of purchase workers' compensation insurance for yourself if you're a solo, but you should talk to an insurance broker because it's probably not the best way to do that. And there might be better options for you. Additionally, if directors and officers of a corporation, if the corporation is fully owned by those directors and officers, they can exclude themselves from any workers' compensation benefits. But once again, that's something you would probably want to talk to about your broker because you'll have to like have that acknowledged somewhere. And you'll need to show all the paperwork for that. And just so we're clear, temporary, part-time, and unpaid employees are covered under the definition of an employee for workers' compensation benefits. And failing to obtain worker compensation coverage, it's actually a criminal offense in California. There's a minimum $10,000 fine, there's additional civil penalties, and even potential jail time. So this is really a must-have for any business. So on top of any liability insurance you get, you want to sort out your workers' compensation insurance. The next thing that's sort of kind of new in employment law in California is this mandatory retirement savings program. It's already required for all businesses with 50 or more employees, but starting on June 30th of 2022, it's going to apply to all businesses with 5 or more employees. So how this works is if you don't have a workplace retirement plan, so like a 401k for your business and for your employees, you have to participate in CalSavers. CalSavers is a Roth IRA run by the state of California. And it's easy to sign up and work with them for that. So don't feel like you're forced to go out and create your own retirement plan, but a lot of companies do because you can get better tax benefits for your company by doing that. Failing to register with CalSavers or implement your own workplace retirement plan can result in civil penalties. So that's definitely something you want to plan ahead for if you are going to have more than 5 employees in next year. So now that we've talked about some of the employment law rules, and I know it's a lot to keep track of, I just also want to touch a little bit on what might happen if things don't work out, or if somebody thinks that you're not in compliance, what sort of will happen or what to expect. And because I've already talked a lot today, I just want to talk about some of the pre-litigation and non-litigation complaints, because if you ever get sued with a civil complaint, you definitely need to get a lawyer, but there's a couple other things that can happen along the way.
And Alyson, I don't mean to interrupt, but is this pretty common, or are we looking at something that happens very few and far between kind of times?
So these are fairly common, I would say. There's a lot of what we call mill firms in the industry, and they pretty much any disgruntled employee will come to them and they'll send you, for example, a demand letter. So that's something that does come up fairly often if you have 5 or more employees. I would say you have somebody you've terminated, there's a good chance you're going to have somebody file a complaint against you. Okay. It's just how it is kind of in California. So first of all, there's internal complaints. So if somebody ever raises an issue with you that they feel that they've been discriminated against, that they've been harassed, that there's something wrong with like their meal and rest breaks or their wage statements or anything like that, that is a great time to proactively get involved and try to resolve it so that you don't have to get to the next level, that nobody makes a formal complaint, nobody involves attorneys. That's really the great time for you to jump in and try to fix things. So, start an investigation, document what you did to make sure that you understand what's going on. And if it's something like sexual harassment or a race-based discrimination, you probably want to try to do something temporary to alleviate that situation. So if somebody's made a complaint about their supervisor, for example, you don't want to just sort of let things stay until you figure out what happened. You do want to try to come in and figure out a way to, for example, keep those 2 people apart in the workplace so that they're not going to have these issues. But be careful. you don't want it to come across as retaliatory anyway. So for example, if an employee complains that a supervisor has sexually assaulted them, you need to move the supervisor to another schedule or to another location, not the employee who complained, because that's just going to open up another can of worms. So definitely, if you can head things off, that's always great. And so I always say it's really important that you tell your employees that if they have a problem, they should come to you or whoever is handling HR, these issues in your company. That way you can kind of resolve these issues before they get more dire. And always, if you have somebody that they can complain to, always have more than one person, because let's say they have an issue with that person, or that's the person they want to complain about, they need someone else they can go to and safely talk to. So you want to encourage people to come to you with issues so that they don't go out and go to an attorney or something else. I'll just quickly also mention what demand letters are. So basically demand letters, usually that's from an attorney, and they'll write a long letter and tell you all the reasons why they think that you are liable and they're going to win at trial. And you have an opportunity at that point to sort of figure out what the complaints are, get your records together, make sure there are no issues. And you can also resolve the case pre-litigation. If you do get a demand letter, I do say you should get an attorney involved, because the other side already has an attorney involved. But make sure there's usually like a deadline listed in the demand letter, and even if you haven't been able to find someone to help you yet, make sure you respond by that time, just to let them know, like, hey, I'm taking these complaints seriously. I want to discuss this. I want to resolve this. I just need more time to find an attorney, or something along those lines, so that they don't go out and file a lawsuit. And then what's much more likely to happen, or not, I shouldn't say much more likely to happen, but it does seem to be happening more often now, is people are just going to make complaints with the DFVH, which is the Department of Fair Employment and Housing, or the EEOC, which is the United States Equal Employment Opportunity Commission. And they enforce those laws that we sort of talked about on that first slide. So their focus is mainly on discrimination, harassment, and stuff like that. And if somebody wants to bring a claim for harassment, discrimination, they have to file with the DFVH or the EEOC first and get what's called a right to sue letter before they can sue you. They can also have DFVH or EEOC conduct an investigation, but it's not required. If you do get a notice that somebody is conducting an investigation, or the DFVH or EEOC is conducting an investigation, once again, I would say you should get a lawyer involved, just because there's a good chance that the other side has a lawyer involved and is planning on suing you. And the last one is just labor commission complaints. So this is a little bit different from DFVH and EEOC, because it's sort of an alternative way instead of having civil litigation. It's designed so that employees can do it without attorneys. So oftentimes attorneys are not involved, and it can cover anything from discrimination, harassment to wage and hour issues. And it's much more common for wage and hour issues. So you terminate an employee and they weren't given their last wage statement on time, or their last pay on time, they might go to the Labor Commission and file a complaint. These are designed so that you don't need a lawyer, which you can kind of muddle through it on your own. If it's a really high value case, and they can add up with all the penalties, if it comes up to something like, $10,000 or something, you may want to at least talk to an attorney, talk about how to present your evidence. And how Labor Commission hearings sort of work is you get sort of this written complaint, you get a chance to respond to it. There's usually an informal phone call where everyone sort of talks about what their positions are. And then there's like an official hearing that's similar to a trial, but a little bit more casual. But you can present evidence and present witnesses, and the other side gets to ask questions of them, and vice versa. And you have sort of your version of, or kind of versions of opening and closing statements, and the commissioner can also ask a ton of questions. So sometimes it's really helpful to have somebody help prepare you for that, just because even though it's designed to not need an attorney for, it can be kind of an intimidating process. But hopefully none of this will ever happen, but labor commission complaints, if you do Those seem to be fairly common now because they are very, very easy for people to file and fill out the forms. And if you don't keep good records of meal breaks or rest periods or something like that, there's a good chance somebody will just feel like, okay, well, I might as well just make a complaint. Maybe I'll get some money from it. So something to sort of keep in mind. And lastly, the best way to prevent getting sued by a former employee is really anytime you end that relationship, you enter into a separation, severance, and general release agreement. So basically you give them some money, like a little bit of severance pay. I recommend at least 2 weeks. And even if you don't feel like you need to do that, that you have a good reason for their termination, it's often wise to do that, because if they do enter into a settlement and general release, they often can't bring claims against you later on. So it's sort of a way to avoid trouble in the future. So I know that was a lot and it was kind of a crash course in everything. So I wanted to also give you guys the website for DFVH. And this is really helpful because it has a lot of information for employers. It has information like on trainings, on wage and hour issues, kind of summarizes some of the things you need to do. So very helpful resource to kind of get more information if you have any, if you're sitting there 4 weeks from now and going like, gosh, when am I supposed to give meal periods and rest breaks? Let me look that up. That's a really good source for that.
Thank you so much, Alyson. That was like you said, it was a lot, but it was amazing. It was a lot of really good information in there. So I saw there were a lot of questions coming through in the chat while you were giving your workshop presentation, and I was maybe Stephen, did you want to read through them, or if any of you want to just ask outright, we can have you do that. If you do want to ask, do make sure to turn your camera and video on. And yeah.
I do know that a lot of the questions that were asked were answered throughout the presentation. So yeah, so if your question was not answered, please speak up. And it looks like Ray has a question. Go ahead, Ray.
So one of the questions was that outside US contractors, there's a lot of engineers now. I'm getting peppered by all kinds of people, you name it, Ukraine, Mexico, Russia, Europe. If I hire them, they're completely outside the bounds of all of the requirements, is my understanding.
So usually they're going to be 1099s for the most part, because they usually have their own company that you're kind of paying through them, and you're outsourcing work that you're not handling in-house. And for the most part, they're going to be people that you are not sort of micromanaging, supervising. Like you'll give them a project, they'll give you an end product, you'll give them feedback back and forth kind of thing. And so that, yeah, those would likely fall under independent contractors. So then you don't have to worry about the hourly issues or exempt issues.
Okay. And
but the standard employment laws still they're still applicable, even though
yes, I mean, you can't like harass or discriminate them or anything like that. Yeah, those laws do not go away no matter what, just wage and hour issues.
Just as another thing, I had somebody reach out from China who wanted 1099. Don't ever do that. I investigated it, and China will slam him and you if you hire somebody outside of their, I don't know, they've got a whole process. You're not allowed to hire people in China, basically.
Yeah, there's a lot of restrictions in hiring firing people, even if you're outsourcing things. And also there's just general business concerns that, like, if, for example, if you're hiring them for tech stuff, you want to make sure that you have full control and there's no backdoors or anything like that, because if there's privacy issues, you can be on the line for that. So always a concern there. Also, if there's ever a problem with the employment relationship, like they don't deliver and you've already paid, you're kind of out of luck. You're not going to be able to sort of get that back. Like, sorry, like that's just, you're not gonna be able to file a suit in China and try to get your money back. So always just be cautious with those relationships. Sometimes it does seem a lot cheaper to use someone abroad, but you don't have those protections that you would have from using someone here.
Okay. I have one more question and then I'll shut up. So what level of ownership is needed in a company in order for an employee now paid to be considered a member of an LLC?
So
Because then I can get rid of the requirement for the workers' comp.
yeah, so there's not sort of a strict cutoff, but it usually has to do with more of the control issue. Like if you just give them like, hi, you get 1% of the the gross or whatever,
Yeah,
but they're
1%,
they're
yeah.
not like a director officer. They don't have any control in the company or any voting right, you know, anything like that. It's not going to really fly that they're really a director or officer.
Okay, so basically they need a title along with the
And responsibility.
And responsibilities, and some stay in the company.
yeah, they'll have a whole list
Like
of
you can't just make
responsibilities.
everyone a 1% person and get rid of it. No. But you know, the workers' comp insurance is not it's not as expensive as like health insurance. So
That's true. It's like $1, I think. Yeah, it's not much.
it's not as bad as health insurance. So don't freak out too much. And a lot of companies will also sort of combine services where they will provide you like payroll, some basic HR stuff, and tie it together with workers' compensation insurance. And a lot of smaller companies will do that. So you can kind of get the benefits. And by outsourcing HR, I mean, they'll give you like the flyers that you need to hang up at work and things like that.
Oh, that do have another question.
Right, quick, make it fast.
Yeah, flyers, those flyers, the policy flyers, right?
Mhm.
Yeah,
we're all remote. So
right. So what
I
you
put
do
them
when
in a drive, and I'm praying to God that's good enough.
You would also probably want to email them out to people, sort of just
email
a while. That's a good way to do them. Email them a copy of it as well. Yeah,
right, it'd be notified, right? You can't just
it's basically they have to be able to see it and know it.
No, I sent them an email with a link, and I said, "Here's where it is." So that should be okay. Okay, I'll set up.
It should be, hopefully, as long as they're aware of what they can do.
Well, this is the trials and tribulations of a startup, you know. It's just like
Yeah, there are so many things to know. So I'm sorry, Ray, to rush you there. I know Ritika had a question as well. Ritika, would you like to ask?
Yeah, my question's around seasonal employees, like temporary instructors during camp season. I run a enrichment camp program, and if there's only going to be hired through summer or certain times of the year, and they're only for like certain weeks, you still have to put them because they don't feel fit those, or they do pass the ABC test or do not pass the ABC test, whichever way. But they're not like, I mean, they're not long-term employees.
So during the time that they're employed for you, yeah, you should have workers' compensation insurance for that time period. Once again, it is very beneficial if you get hit with a workers' comp claim to have that insurance. So just during that, but you just need it for the time period that they're working there, not like for throughout the rest of the year. And I would recommend, even though they're not, they might not be full-time employees, like as part of the orientation or whatever you do, to do some basic training for them for discrimination issues, for the mandatory training, just to have that as part of your orientation program. Simply because that way you avoid any concerns about it. And also if there turns out to be an issue later on, you can say, look, we give trainings to everyone, even if it's not required. So like, we really make an effort to make this a safe environment.
So in addition to that, so do they have to be on payroll and everything? You cannot just pay them through a 1099 or expense kind of deal?
I would have to, I can't tell you off the top of my head whether or not. I'd have to look through the exemptions. There are a lot of exemptions that apply for that. And I can't tell you off the top of my head. There's over 100 different exemptions that were just put into law last year for that. But I know sometimes teaching and stuff like that is not, that you can 1099, but you have to carefully look.
Yes, especially because
saying it. But yeah, and once again, always important err on the side of caution.
Awesome. And there,
Yeah,
there's
just
so many
sometimes you,
changes to 1099 law. Sorry, Ritika, go ahead.
no, I was just saying that sometimes you are, like college kids on break or high school students or so do they all have to be put through the employment?
Sometimes, so it depends. It's going to depend.
Yeah.
It's a case by case. So yeah.
And the laws have changed. It's very different from what it was like 10 years ago of how it has to be done. And that's because of the case from 2018. It really changed everything for 1099s in California.
Mhm. Yeah.
Okay, I'll look that up. Thank you so much.
Mhm. So I think we might have time just for one or two more questions. I saw somebody
I
just.
think Philippe had a question too. He's like, I think he asked what applications or software, I think he might be asking, do you recommend for tracking wage hour for employees required by law?
Either
So-
software or if you have a firm that you recommend outsourcing to.
Yeah, so there's a lot of different companies that do it. So I don't really have a preferred one, and you'd have to shop around for time for that. And there's some that do it like by finger scanning. There's some that just do, you enter your own time or you clock in, clock out. You don't have to have a fancy system. You can actually just have people record it literally on paper. You just have to make sure it's actually being recorded. And there's not a humongous difference in having someone enter their time online versus entering it on paper, unless you really are doing a clocking in, clocking out system. So you don't have to necessarily do something fancy for it. You just have to be able then to look at it yourself and go through it. Also, something to remember is that a lot of times when you hire companies to do your timekeeping, they'll automatically record some of the overtime, like the daily overtime, maybe the weekly overtime. They won't always catch that 7th consecutive day issue.
Mhm.
And I don't really know any of them that really catch meal or rest breaks. So that's something you really have to look at on your own. So I don't have a particular suggestion. I know a lot of people will use the programs provided by ADP.
Sure.
Has their own, that's like if you're using them for doing payroll, I think they have their own application to use.
Yeah, there's a lot of combined services nowadays, right?
Yeah, there's a lot of combined ones. So if you're going through somebody else to already do payroll, see if they have one recommended for it, because that will just save you time in entering it into their system. But once again, you don't need to, you can use the old-fashioned cards, like that's totally fine. You just have to make sure that you're checking it weekly, basically.
Yeah, and then I saw there was a question, somebody asking about, Karen was asking about when you have to notify people about their 1099s, the threshold, it's the $800 or less. Do you want to ask the question, Karen, or?
Yeah, I didn't make it really clear. So you hire somebody for an independent contractor, you might, let me make it like simple. And you may know that the cost to pay them might go over $800.
Isn't it 600 or 700, or is that right at 800?
I think Ray just posted it was 600.
Yeah.
It's definitely.
Am I on this or what? Yeah, it's 600. So 599 is a good number.
Yeah.
Okay.
So, right, it's so low, so it's more than likely it's going to be more than that. Do you have to like legally inform them that they're going to have to file and pay for taxes? Do you have to?
So I mean, you will have to have gotten from them the form, because you have to issue. So they have to give you a W-9, because you have to issue the 1099. Now, whether they pay taxes on it is not your problem at that point, but you have to make sure that you've issued it in time.
Right.
Okay.
And I don't know, Alyson, how you feel about this, but I always, even though the employee is required to give you the W-9.
I mean, I give it to them and tell them to give it to
give it back, right? Yeah.
Yeah.
So.
Yeah, that should be part of any time when you're hiring someone, you onboard them, you give them the W-9, or just so that you have it, so that you remember to do that for your paycheck. So I always recommend that. The same way like you would normally, if you had a regular salary employer, hourly, you give them a W-2 while you're onboarding them. Just, I would do it the same.
Right.
Thank you. That
Well,
answers my question.
Oh, good, good. Well, I think we're out of time for questions now, and so we're gonna have to end it there. I know that people still had maybe some more questions, so if you do, you can always reach out to Alyson through the rec or any of us. There's a survey that Stephen put in the chat. We'd love it if you could go ahead and answer those questions. And Alyson, is there anything you'd like to leave us with as we end this session?
Feel free to reach out to me if you'd like. I'm gonna put my email in the chat too, and you can also find me on LinkedIn. It can feel really overwhelming when you're starting a business because there's so many different rules and things that you have to think about that nobody tells you about when you start a business. Like, you register with the Secretary of State, they don't give you a list of the 20 things you need to do. But take that time to make sure that you're in compliance, and just remember, this is just one step in being a business. Once you have things set up properly, you're going to be fine.
Thank you, Alyson. Thank you everyone for coming. The recording will be available very soon on our YouTube channel. Make sure to follow us there and on all our social media. Take care, everybody. Have a good rest of your weekend. Bye, everyone. Take care. Hi, everyone. My name is Tanya Hertz, and I'm the director of the Regional Entrepreneurship Center, the Rec Innovation Lab at San Diego Miramar College. And I'd like to thank our partners at this time and give a special thanks to SDSU's Lavin Center, the SDSU Zip Launchpad. We'd like to thank the California Entrepreneurship Educators Conference. Also like to thank Harness, the Brink SBDC at USD, San Diego Unified Schools. We'd also like to thank School of Entrepreneurship and Technology, High Tech High, the Regional Advisory Committee, Alex Waters at the Jacobs Center, Connect All, 21 IQ Labs, Startup Quest, Productified. I'd like to thank Course Key and Tech Coast Angels. Thank you to Village Up, City Heights Development Corporation, San Diego Angel Conference, Startup San Diego, SBDC, SCORE San Diego, We Are Kingdom, New Media Rights, San Diego Tech Hub, Origin 63, Ambrosio 15, OmniSync, Optima Office, Proven Recruiting, Craft Leadership, GS&L Consulting. Thank you to all of our partners. We couldn't do what we do without you. Thank you.